Okay, so I'm going to just, before I forget, I want to remind you that your exam is next week. So 1 week from today is your exam. And again, if you go to your syllabus, you will see that it states March 1st is the exam. The exam is going to be on Blackboard. And I'm starting with the exam stuff now while you're all still fresh on there, not after we finish the entire lecture. So the exam is going to be a combination of multiple choice questions predominantly. So you have a 1 in 4 chance of getting things right, and some true and false, but not that many. I will wait until after we finish class tonight to kind of finalize the exam. And next week it will be posted on Blackboard at 6:30. The exam is open book. So you can use your notes to do it. And that's because it's open book, I'm not going to provide you with a review. So if you just go back to your lecture notes, especially the things that I say, write it down, you will be fine for the exam. Some of the questions, they're not just straight up memorization, it's understanding certain concepts, making sure, drawing analogies about what certain cases stood for, and then comparing that to a particular issue that's presented. I don't think the exam is hard, but that's just me. So I think if you pay attention in class, and if you've done the reading, you will be fine. You'll absolutely be fine. You're going to have the entire class period to do the exam. It's going to be more than 25 questions, but less than 50. So, so that kind of gives you a rough idea of the time. If you have a documented disability, and I've already been notified of it, again, a documented disability that requires more time, I am aware of that. So don't worry. You'll be able to have more time if necessary. The exam, again, you need to check your internet. You need to make sure that you're able to take the exam without interruption on that day. I am not technologically savvy, so it's once you start, you need to be able to finish it. You're going to get one shot to do it, and then you can mark it submitted, and then you'll get your grade right then and there. Um, and that's pretty much it. Do you have any questions before I get started on the lecture for tonight? Anyone?
It'll be on Blackboard, right?
Correct.
All right, cool.
And sorry.
It's okay.
Hi first. And as usual, we focus on the things you discuss in the lecture.
Right.
And then, but sometimes let's say the paragraph is really too big and there's stuff you didn't even go through. Are we required to study those as well?
No, no. If you study the lecture notes and you follow the things that I've gone through in class, you'll be fine for the exam. There's stuff in the textbook. I don't think there's anything I test on that I have not discussed in class. And that's why I always wait until after the last class, and then I go over the exam to make sure that the questions I'm asking you are things specific to the lecture that I gave you.
Okay, good. When I was preparing for the class as well, so I follow the syllabus and then I attend as well whatever YouTube you have. So for today, there is a case actually Freeman versus Bars. You
Yeah.
said you always test on it.
Yeah.
So this is not in the book. I have the 13th edition. I have a PDF online. Both of them different editions and both don't have it. Well, I Googled it
I
to
also
study it, but it's not in the book.
It's not, and I know it was definitely in the 12th edition. So
I have the 13 edition as well, and
okay,
even the I think the PDF that I have is a 12 edition. So I checked them both, and they don't have it.
that's very strange. Did
I
anybody else
pulled
have
it up
that?
online.
I teach this class on Wednesday evenings, and Wednesday
Well,
did not have a
someone there
problem.
said it. I was surprised. How come nobody said mentioned anything
Yeah.
when I attended it? So someone told you that they didn't find the page where it is. Actually, it's not even there. So that's why he didn't find it.
So when I prepare my lecture, I base it on the textbook. So when I prepare all my notes, it's based on the textbook. So I don't add anything outside. So in the 12th edition, at some point the hard copy did have that, and that is a case I ask about. So certainly, if it's on the syllabus and I'm going to discuss it today, definitely then pay attention.
So just to be clear, so I googled it to get what was it about. I wrote it on my book.
Okay.
What is it? But for confusion, I think everyone who doesn't have it needs to do that. Pull it up from Google.
Yeah,
Then.
there's a lot of cases that are in the textbook that I don't include in the syllabus, and I've taken out and I don't include in the lecture. Some of them are just, either difficult concepts or I don't really need to go over. But Freeman versus Bars is a case you should know. And we're going to talk about that today. Does anybody else have any questions?
Nope.
All right, so let's get started on the material. So if you go back to the syllabus, I know that last class I said that we're going to hold off on the last chapter of the material from February 8th because it also has to do with property, and we're going to go add it to today's stuff. So today we're going to go over chapter 47, 48, 49, and 50. All those chapters have to do with different types of property. So when you go and you start with chapter 47, we look at, first of all, some kind of terminology. And what we're going to do is we're going to talk about generally the different types of property. And the first umbrella that you kind of need to kind of keep in mind is tangible versus intangible property. So when we talk about property, one of the generalizations that we can have is between tangible and intangible. And you need to know the differences between tangible and intangible. So who can give me a specific example? Don't define it. Give me a specific example of something that is tangible.
Can I give it, Joseph
Yeah.
Gallo?
Yeah, go ahead.
So like a house.
Okay, a house. I want you to also keep that in mind for another question I'm going to ask a little bit later. But yes, a house is an example of tangible property. What else?
Furniture.
Furniture.
Cars.
Car. Land. Okay. What else? Tangible.
Tools.
Tools. Yep.
Phone.
Phone. Yep. Tangible property is anything you can touch. That is a remote, a phone, a pen, a notepad, sharpener, whatever. It's tangible. It also includes real property, things like the house, the land, and things of that sort. So that's tangible, things you can actually touch. Give me specific examples of intangible property.
Feelings will be intangible.
Say that again.
Feelings.
Ceiling?
Feelings, like feel.
In a house?
Emotional feelings.
Oh, feelings. Is that property? Is that an intangible property? I wouldn't, because don't forget, it's still property. It's still some type of ownership. So
Patent. Copyrights.
Copyrights, right?
Would it be like stocks?
Stocks, yep, absolutely. Bonds, somebody else wrote that. Yeah, it could be somebody wrote air travel rights. It's intangible. So yeah, we can, the space above your home or where you live, like that, travel space. But yeah, intangible property, also it's the stocks, the bonds, copyrights, patents, and things of that sort. It's something you can't physically touch, or if you do touch, cash is, I wouldn't put cash as intangible, only because the dollar that you hold specifically speaks for itself. That $1 is $1. But when you own a stock certificate or stocks in a company, that stock is a representation of something else that you own. It's a representative. So intangible property is property that you can't, maybe you can't touch it and hold it, and it has a different representation to it. So that's why, like a copyright or a patent, it's a piece of paper that represents something else, ownership of that other issue. So when we talk about, again, property, generally, we have the intangible, things you can touch, and then we have the correct cash. But perhaps a check or, cryptocurrency is not tangible. So cash is, when we talk about money, but not the other stuff that I just mentioned. So again, property, tangible, intangible. Now we go into subdivide again, tangible property. And then within tangible property, there's two different types of ways to classify that. And that is personal property and real property. So we started out with the general umbrella, tangible versus intangible. And then within personal tangible property, we have personal and real property. So can you give me an example of real property?
House, building,
A house, a building,
land.
land. Yeah, that's pretty much the stuff that covers real property. So real property is the house, it's the land, it's a building. And what's personal property? Give me specific examples of personal property.
A phone,
A phone,
wallet,
Jewelry.
a wallet. Somebody else said it, ring, I think.
I said jewelry.
Jewelry, yep. And that's personal property.
Anything that's not real property.
Anything that's not real property. Furniture, yep, exactly. Those are examples of personal property. Now, the next thing we're going to talk about also within the realm of personal property is fixtures. And in order to do that, we're actually going to talk a little bit about real property. And when we talk about real property, I'm going to actually bring this example up now because I think it's a good segue for it. We're going to play a game. Now, Amar, you've taken this class before. I don't want you to answer, so don't blurt it out. And I'm not going to pick on you if you do. I'm going to give you 5 things. One of them is not like the other. So there's 5 things I'm going to tell you. I'm going to name off. One of them is not like the other. And I want to take a show of hands to see who knows which one is different. So we're going to start with a detached home. I'll even put it in the chat for you to make it even easier. So detached home, semi-attached home. Number 3 is a townhouse. Number 4 is a condominium. And number 5 is a co-op. Which one of those is not like the rest? I'm going to ask for a show of hands. How many people think that the detached home number 1 is different than all the rest? No, go. Okay, 2 hands, 3 hands. Okay. How many people think that the semi-attached home is the, no, go. How many people think the semi-attached home is different? Nobody, okay. How many people think the townhouse is the one that's different? Nobody. How many people, 1 person, okay, townhouse. How many people think the condominium, condo is different? 2, 3, 5, 6, 7. So this is the condo, 8, 9, oh, that's a lot, okay, 11. Okay. It's going up and down, up and down. How many people think the co-op? Now the co-op. How many people think the co-op is the one that's different? Okay, so most of you think it's between the condo and the co-op. And you would be correct if you picked one of those. So now we're going to narrow it down. And now I'm going to ask for somebody to actually explain why you think you're right. So who thinks it's a condominium? And then be ready to tell me why that's different. Who wants to stand by their vote? Why you think the condominium is different?
Sure.
Go ahead.
Because it's not something that you like own. It's something that you kind of like rent. Like you can
own a condo.
Well, it's something that you have to like pay to maintain and it's part of a community,
It
not just
is.
like a singular house that you own?
Okay. It is part of a community, but that's not why that's different, if that is in fact the case. Anybody else think it's a condo and wants to help Christopher? Not you, Christopher, the other Christopher. Anyone else? Okay. How about co-op? Who thinks it's a co-op and can defend their answer? And then you have to speak out loud.
I can do it.
All right.
Just from the reading, you don't own a co-op, you own like shares of.
Ding, 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 ding. Ding, 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 ding. With a co-op, you don't actually own the land itself. You don't actually own the apartment. Condos and co-ops could seem exactly the same on the outside. Even if somebody were to come in and visit you in either one, right? It's exactly the same. Usually it's an apartment of some sort. Usually there's a board. Usually you have these maintenance fees you have to pay. The difference is, the primary difference, and the only reason why a co-op is different than the rest is because with a co-op, you do not, and this is a write it down moment, co-op, you do not own the land itself. You do not own the building, the apartment, the walls. You own shares in a corporation. It's the corporation that owns the building. And you have X amount of shares with an exclusive right to live in a particular unit. So when you pass on, and we're going to talk about this later when we talk about wills and trusts and stuff like that, and we look at like how distribution is done after somebody dies, if you own a co-op at the time of death, it's considered personal property, not real property. It's considered personal property, not real property. Does anybody have questions before I move on to the next thing? Okay, so again, we're still talking about, real property, and we're talking about, now the next we're going to talk about also within property, real property, is something called fixtures. So if you've done the reading or you're familiar, give me a specific example of what a fixture is.
It could be a door.
A door?
Yes.
A kitchen cabinet?
A kitchen cabinet is a good example. The door, it could be, but you would have to now give me more details as to this door.
I don't remember where I saw it. I don't know if it was in a Google example. It was, I think it was a case. Somebody broke a door or something. They had to repair it, but it wasn't the landlord's responsibility.
Okay. Hold on to that thought, because maybe when I give you the definition, we'll see if you still want to use that as the example, because I try to give you guys real solid examples of what something is. That way you can kind of like, when you're studying, you can refer to that particular example. So a kitchen cabinet is a good example of what a fixture is. What else is an example of a fixture? And then we're going to go into the definition.
Like a fireplace embedded in the wall. If you remove it, you're gonna damage the whole thing.
Yep, exactly. A fireplace that's embedded into the wall, not the type of fireplace that you find in Costco that you can buy and it's like a piece of furniture. Like that one, it's in a box, you put it in, it looks nice. That's not a fixture, but the fireplace that's embedded in the wall, that's got like concrete and what's it called, those tiles and things like that, that itself is a fixture. Lights, it depends on the type of light. Ceiling fan, it could be. And now when we get into those smaller things, wall lights, yeah. So let me now give you the example or the definition of what a fixture is, and then you tell me if a ceiling fan would do or if the lights would do. A fixture is something that is affixed to the wall that becomes part of the land itself once it's installed. And if you remove it, you're likely to cause damage. So with kitchen cabinets, when you move from one apartment to the next, or a house from one house to the other, ask yourself, do you take the kitchen cabinets with you, or do they stay with the land? They stay.
Stay with the land.
I've never seen anybody take their kitchen cabinets with them, right? But when you do leave, do you take a lighting fixture?
It depends.
It depends. You could very well take a lighting fixture with you. If you had I was about to say that exactly. If you had a beautiful chandelier that you purchased, you could possibly take that. It does not stay with the land unless by removing it, you're going to cause damage to the ceiling. So you can remove, like, the spotlights, windows. Yes, windows are fixtures. Like the hi-hats that you're putting into the ceiling, right? Though you can remove the light bulb, but if you remove the whole embedded thing, you're going to cause damage to the ceiling. So a fixture is something that once it's installed, it becomes part of the land, part of the wall, part of the living space. And this is the perfect segue, a wall mount. A wall mount would be an example. But if you remove it, are you going to just have like little tiny holes, or are you going to rip out sheetrock with it? So I guess it depends on the wall mount. When we talk about these things, the reason it's important, actually, not just for purposes of business law, but if you're ever moving or if you're buying a place, one of the things you want to keep in mind is don't assume certain things come with the house, right? Don't assume certain things are part of the purchase price, because a chandelier is actually the perfect example of something that could cause problems when you're selling a home or purchasing a home, because you, as the purchaser, you might think that the ceiling fan, usually that would, they're not going to remove that, but like a chandelier that costs thousands of dollars, they might say, no, we're going to take that with us. You may assume that it's going to stay, but if they can remove it and put a little cheap little light bulb there and without causing damage, then it's not, that's fine. That's why it's important when we talk about contracts. You're going to see how important it is to kind of discuss these things and make sure that everybody knows where everybody stands. So the case I want to now talk about, which is the perfect segue to this, which also clarifies the meaning of fixture, is Freeman versus Bars. So who read it that wants to tell us about Freeman? Amar, since you brought this case up earlier, why don't you tell us about it?
Okay. So Freeman, he sold his property to Bars, and then it had I had to read some, and then it has some resident and barns, and in one of those barns there is a huge and very heavy cattle scale, and then it was like cemented to the floor, and there was like bars, iron bars around it, and even ramps leading to it. So if you remove it, it's going to cause a lot of damage. And then he was suing that he bought it for $11,000 and he want to take it. And then the court considered that it's a fixture. So once he sold the property, because of the way it was installed in the floor, so it cannot be removed. And they didn't give it to him because it turned into a fixture. Even that he bought it as a portable, actually. Like he didn't buy it for it has to be cemented. He bought it as a portable, and he's the one who cemented it to the floor. So
it's exactly because he cemented it into the floor that it became a fixture. So even though something was initially a freestanding item that could be moved, once you now embed it into the ground concrete, and it's like it was a very, very heavy item that's not easy to move, it becomes part of the land itself. So does anybody I always ask a question on what a fixture is, and I give examples, and you have to be able to identify. So does anybody have any questions about a fixture, what a fixture is, or is it pretty clear? FYI, also on the exam, I'm not going to ask you things to try to trick you. I'm not going to ask you a lighting fixture. I'm going to be specific. So it may be like, or a fireplace that's freestanding versus a fireplace like a furniture piece. So you're not going to have to think, oh, which one does she mean? No, it's going to be clear because I want to know that you know what a fixture is. So any questions? No. Okay. Okay, the next thing we're going to talk about is transferring of title when we have personal property. So if I own something, and we're just going to talk about something, forget real property because real property is a little more involved. But if I own personal property like a phone or a notepad or a pen or whatever, what are the ways that I can transfer ownership? So the ownership can go from me to you. There's a couple of different ways.
Can
I
sell
can,
it.
yeah,
In a will.
and gift as a gift.
Yes, correct. As a gift is one. Somebody wrote sale, right? Is there any other way?
What about a will? Like
A
you,
will, excellent. Yep. And a trade. That's it. That's
Trade.
perfect. That's all of them. Yeah. It's a sale, probably the most common thing. A will, when you will it to somebody else. A gift, you can just give it to somebody. And then the last one is a trade. Very good. And what happens when we actually transfer ownership? It depends on which medium we're actually going to be using. So if we're doing a sale of an item, I'm going to sell it to you, right? So if I give you the phone, what are you giving me if it's a sale?
money.
Money, exactly. What about if it's a trade? If I give you a phone, what are you giving me?
Different item.
A different
Equally
item.
valuable to the phone.
It's going to
Wouldn't
be
it be?
something that I think in my eyes is valuable as equal valuable to the phone, right? If I'm gifting you, what do I have to do?
You have to deliver the gift to
I
the
have to
person and
deliver.
without any consideration.
Exactly, exactly. When we give a gift, it has to be delivered, and I have to have the intent of you receiving it, and you have to accept it. If I'm giving you something and waiting for something in return, that's not a gift, right? That's a trade, or that could be considered a sale. But if I give you a gift, it's there's nothing contingent on it. At this point, usually in the semester is when I like to talk about the proposing an engagement ring, right? And I always tell the story of a colleague of mine who wanted to propose. He had been with his girl for a long time. And I was like, when are you getting married? When are you getting married? So he finally decided, okay, this was going to be the time he was going to propose to her. So then the lawyer, in me kind of kicks in, and he wanted to do it on a holiday. And I was like, you don't want to do it on a holiday. And why do you not want to propose on a holiday? Why do you not want to propose
Because
on Valentine's
it
Day?
can be misconstrued as a gift.
That's right. That's right. If you give a diamond ring or some kind of ruby ring or some kind of, any ring on a holiday, what if the engagement breaks up and she says, or he says, whoever you're proposing to says, no, 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 this wasn't an engagement ring. This was actually my Valentine's Day gift or my birthday gift. So you don't want to propose on a holiday. Forget romance, forget love. Don't forget that marriage is simply a contract between two people. That's all it is. So you also want to keep in mind any repercussions that could happen. Now, it has been accepted that depending on the jurisdiction, that if you propose on a non-gift day, that it's not considered a gift. It is something in anticipation of a contractual obligation, right? I'm giving you this ring so you can marry me. Therefore, if you don't marry me, I should be able to get the ring back. So that's one argument that some people make in when the engagements break up, why they want to get the ring back. And that's why it's important not to get married on a holiday. Yes, exactly. That's why I give these personal pieces of advice to kind of help you guys out in your
Or don't get
personal,
married.
or don't get married. That's right. That's also something. Tips for the future. Don't get married. And if you do, don't do it on a holiday. So what he wanted to do is, and again, because this is a real story, he still wanted to do something romantic. He proposed on solstice day. And I was like, what the hell is solstice day? It was like the longest day of the year. So he kind of compared, I think how it's the longest day of the year. It's the brightest day of the year because she lights up his life, and his life was darkness before she, all that good stuff. But it's really not a holiday because people don't usually exchange gifts on solstice day. So he's able to, do that. But I believe he also did a prenup. So that also
Did
kind of
they end up
calculates.
married?
Yes, they've been married. They've
Bingo.
been married for a couple of years now. So yeah, he's good. So that's about a gift, and that's the importance of consideration, which we're going to talk about consideration at length the second third of the semester, because that's when we talk about contracts and gift giving in general. What else do I want to tell you here? Oh yeah, I think I already said this before, but gift cannot be conditional. So when you're giving a gift, it cannot have any strings attached to it. Property insurance. Okay, next thing is property insurance. When you mail something, have you ever seen any request to like put insurance on it, to like, you know, if you're mailing something with UPS or USPS or anything like that? Yes. What's the purpose of insurance?
In case that item that you're sending gets lost, damaged, depending on what you selected, that's how much they're willing to reimburse you is.
Exactly. And that's what it is. It's basically insurance in general is an agreement where the person who's receiving the compensation insures against, you know, whatever the value is. So if something happens, some kind of damage or a problem with it, then you get that money, whatever you actually insured it for. There's different types of insurance, obviously. What is the most common, you know, what have you heard about, like something that's, you know, you hear about all the time as far as insurance when it comes to personal property?
Car insurance,
Car insurance, that's
house
right.
insurance.
Life
Car
insurance.
life insurance, yep. Now, life insurance, it's not insurance over property, right? It's like over a human life. So we'll start with car insurance, and then we'll talk a little bit about life insurance. So car insurance is mandatory in some states. You have to have it. And the purpose of it, again, is if you get into a car accident, then you are either compensated or the person you get into the accident with are compensated. Life insurance is sometimes a little bit trickier, right? Because it's not so much if you die, you know, there's an automatic payout. What if you filled out the insurance, and there's always some kind of application process, right? And they usually ask if you smoke. That's one of the questions that's asked there. And let's say you lied because you actually smoke like a chimney, but you put down that you don't smoke and you end up dying of lung cancer.
They revoke the policy and the beneficiaries doesn't get anything.
Exactly. The policy is considered fraudulently obtained because you entered into a contract with the insurance company, you filled out this application, they insured you based on a false premise. So while they may return the premium to you, the money that you paid out every month to your estate because you're dead, but they're not going to pay out the insurance policy limits. Now, why, you know,
Excuse
what
me.
are the, yeah, yes.
What if you started like you didn't smoke when you were signing the contract, and then you started smoking like afterwards at some of
Excellent question. Excellent question. Um, because my husband asked me the same thing because we were doing like his
They
friend.
usually request medical records because I
Yeah,
work in medical.
right.
So they usually like most of the times keep asking for medical records, or even every few years they would ask for updates as well.
It depends on where you
Reflecting.
are in life. So if you've genuinely, let's say, never smoked, and then you're applying for life insurance policy or something like that, and what they do come to your house, they test your blood, they test all that stuff, and you were not a smoker, but you know, all of a sudden you had a life revelation at the age of 50 or 60 that you wanted to start smoking, um, if they're doing periodic testing or questionnaires to kind of make sure that you are, because don't forget, you're going to reach certain milestones in life, 60, 65, 70, so your policy may change. They may ask a simple question like, has anything happened or changed in your life since the last time you completed this application? So if you say no, but meanwhile, something big as, hey, I did start smoking, has now crept in, well, that gives them the ability to void your insurance or increase the cost, right? But are you going to want to pay more to insure your life? It depends. You know, depending on where you are in life, life insurance or these types of insurances can be expensive. So some people do lie. And don't think that the insurance company is not going to do some kind of investigation or maybe even an autopsy. Do you think insurance companies want to pay out $1 million, $2 million on a life? No.
No, never.
No, they're hoping not to have to pay out. So if they are able to find, if they go to your Facebook page or Instagram page or you have TikTok videos where you're smoking like a chimney, and they see that, that's actually a reason for them not to pay. And I will tell you, there's a case, it was before my time, but I'm going to tell you about this because it actually happened in the news a couple of years ago, the same premise. So husband got a life insurance policy on himself. Later there was an accident, a boating accident. He was not found, and the insurance policy, his wife wanted to do an estate for him, and she wanted to be able to collect money, his life insurance, and he had like 3 policies, and 2 of them paid out and 1 of them did not. This is actually a real case that happened in our court. It's usually what I do a mock trial on back in the day when we had internships. And one of the insurance companies held out. They did not want to pay the policy. What do you think happened? What did they do?
Maybe they said he's still alive.
Yeah, they said he was still alive. They actually had a detective, a private eye, follow the wife around. They saw that the lifestyle of the wife had changed, her and the kids, that she was going to this remote location. Husband had faked his own death, even though he was in a boating accident, and he had friends with him on the boat that swore to the fact that there was this accident, that he went overboard and it was a big storm. And they it was like a fireman, and it was, who was the other person? It was like, I remember one of them was a fireman, the witnesses, and they found out it was a whole big scam. A couple of years ago, there was also somebody from New Jersey, a guy, was like a guy and his son who was above the age of 18. They were at the beach, and all of a sudden, dad's gone. They were trying to file for insurance so they can get the life insurance policy saying he was dead, but he was in fact alive. We actually have another case right now pending, so I'm not going to go into it, where there was a death, we don't know yet because the body was never recovered. Somebody had jumped off the Staten Island ferry. Body was never recovered, and they're trying to prove that the man died. There's actually this thing in the law where if you have, if there was a specific peril, like something that actually happened, and your body cannot be found, I think it's for 3 years, then you can be declared dead by the court. So if you're declared dead by the court, then your estate can actually collect insurance proceeds. So FYI, the insurance is not going to just lay there and be like, yeah, let me pay out millions of dollars. They're going to do investigations to kind of see whether or not you smoked, you did not smoked, or took on any activity that perhaps hastened your demise. Anybody, any questions? Because I think,
Yeah, Professor.
yes.
Where would that be trial? Would it be in civil court or would it be like criminal?
It depends on what it is. So if after they found that the person has committed fraud, then it would be criminal in nature because they engaged in fraudulent activity. Prior to that, when they're not sure if this person is alive or dead, and they're trying to, if it's like the insurance company fighting with the family, or trying to get this estate, it would either be in surrogate's court or be in Supreme Court.
Thank you.
You're welcome. Okay, we talked about that. Okay, so that takes care of everything I want you to know for chapter 47. I'm going to move on to chapter 48, unless you have any questions. Okay, so chapter 48, again, we're still talking about ownership interest. And we talk about ownership interest, we're going to talk about depending on how you own. And I think that the easiest way, again, to explain things is whether an item is a piece of land, a house. We'll stick with a house. How it's owned and how you transfer that type of ownership. When we talk about land, the best type of ownership to actually have is something called a fee simple, F-E-E, the word simple. And when you own something in fee simple, this is now a little bit of legalese, it means you have absolute ownership of it. If you absolutely own something, what can you do with that item?
Anything you want.
Anything you want. Yeah, that's right. You can sell it, you can trade it, you can gift it in a will. You can do all that stuff we just spoke about. But there are some types of ownerships that are not absolute. one example is a contingent ownership. And when we talk and you see the word contingent, right? A contingent ownership is basically it's a qualified life estate. You don't have to write this down. This is a listening thing. I'll tell you when to write stuff down. And it's a qualified life estate is a contingent life estate, which means it's some type of ownership that's contingent, that's premised on either the happening or the non-happening of an event. So I own my home, right? I want to put it in my will that upon my death, I donate my home to ABC charity, and they can use my home as long as they use my home as a resource for students to help students get on their feet and get jobs. As long as they do that, they can maintain ownership of that home. What happens if this ABC charity stops using the home for that purpose?
They lose the privileges to
They
it.
lose the privileges, and that house reverts back to my estate. And usually, if I have something like that, I also have a contingency plan. So, which means if they fail to use it for this particular purpose, then X, Y, and Z happens. So it reverts back. It's contingent upon this happening. For those of you who are from Staten Island, and I brought this up in like other classes, there's actually a house on Howard Avenue. If you've ever heard of Casa Belvedere, it's like now it's like
Yes, it's beautiful.
it's
I
beautiful.
love
It
it
is.
there, Casa
It's
Belvedere.
beautiful. Yes. That was a home. Oh, you worked there. Awesome. So it was actually, do you know the history of it? Of Casa Belvedere before now I speak about it? Vincent? Nope. Okay. So I'm going to tell you, and you're going to, when you tell the owners, they might not even know because they're not actually owners. So Casa Belvedere was actually a home, a prominent home of a family on Staten Island. And they gifted it in their will so it could be used for Italian heritage purposes. As long as that place is being used for Italian heritage purposes, that ownership can remain with this entity right now that runs it. So it is a charitable donation. There are some people who give away their stuff to charitable organizations to be used as that purpose only. And again, if that purpose ever ceases, then that ownership reverts back to the original owner. Don't forget they're dead, but it goes down through their estate and then it flows through whichever other ways that they have. The other types, so now we talked about fee simple, we talked about the contingency factor. Now the next thing I'm going to talk about is a life estate. A life estate is common, especially when somebody is married for the second time. And I will tell you why. Let's say I'm on husband number 2 and I have children from husband number 1. Husband number 2 and I live together. In my will, I give husband number 2 a life estate. When I die, I don't want him to be kicked out of the house. He can still stay there, but I know that really I want ownership to ultimately vest or remain or go to my children. So I give him a life estate in my home, meaning he can live there for the duration of his life. He cannot sell it. He can't sell it. He cannot trade his life estate. There's actually actuarial companies that put value on life estates, but we're not going to get into that for purposes of this class. But I can put in my will that he can live there as long as he's maintaining the bills and insurance and taxes and all that stuff until he dies. And then after that, it automatically transfers to my kids. Let's say husband number 2 is really not paying the taxes, not paying the water bills. He's not taking care of the house, but he does have a life estate. Do my children have any right to go after him?
Yes.
Yes.
Was he devaluing?
Wait, don't say anything, Amar. Don't say. I don't want to call somebody else that hasn't said anything. Who says yes that wants to give me a reason why they can go after or why they cannot?
I would say yes because it was in your will or whatever that
Yeah.
that he has to upkeep with bills and whatever else. So if he doesn't, that's breach of contract. So I would assume that they could sue for that.
But let's say I didn't say, let's say for instance, I did not say in my will that he has to take care of it. But let's say he's letting bills pile up. Can my kids still go after him?
I'd still say yes, but I don't know why I would say yes.
Okay. People are saying yes, and that is correct. They can go after him.
Maybe because like if like he lets the bills go up too much, like they'll like that stuff will get repossessed or
Yeah, absolutely. Yeah, it'll put liens on the house. Don't forget that my children are the ultimate owners of this property. Therefore, they have a right to make sure that the property is in the very least decent shape, that it's not wasted. Their claim would be that he's wasting the home, that he's reducing its value. If you have somebody that's not doing what they're supposed to do, if you've lived in a home or maintained a house, it's a lot of work. And if you don't keep up with it, it loses its value, right? That's value that those kids are going to get. So they do have a right to go after husband number 2 to try to get him to do what he's supposed to do or get him out or do something. They'll have a right to actually go after him in a court of law. Okay, let me see here. So that takes care of waste, future interest. That's fine. Don't worry about the other stuff. Okay. The next thing, let me just take a look at the syllabus. Okay. The next thing we're going to talk about, also in the realm of real property, is when we talk about renting homes, right? Apartments or whatever it is. So we've talked about ownership so far. What happens when you rent something? What does that mean when you are renting something? If I'm renting my apartment to you, what does that mean?
Your
Simplest forms.
You don't own it. You just have the right to live in it. You
Right.
pay the rent every month.
Yeah, you pay a certain amount a month, Samantha said that, to stay there. You don't own it. You are residing in there. You're leasing it. It's a temporary thing. Now, if you be the tenant and I be the owner. If you are renting an apartment from me, what are your rights? What are your rights and or obligations? Raise your hand or give me some kind of sign that you want to speak if you want to speak.
Could you repeat that one more time, Professor?
Sure. You're the tenant and I'm the landlord. What are your rights and or obligations? Give me something.
So some of my obligations will be paying the rent on time
Good.
and not causing any damages to the place that I'm renting.
Good. I think here, I think somebody raised their hand. Mark, was that you that raised your hand? My thing just disappeared. Oh, Taylor, you raised your hand. Go ahead, Taylor.
Yes. So stay in the contract for however long, the lease for however long you sign the contract for.
Good.
Without breaking it.
Great. Good. Follow the rules. Good. Tanisha. Yep. Good. So you've said so far collectively, you have to pay the rent. You have to not cause problems. Vincent, what else? No pets, no pets. Correct. That's right. You have to follow the rules. Vincent, you have something to add? I see your hand is up. I don't know if that's on purpose.
I feel like technically, isn't the owner not allowed to come into your property without your permission?
It depends. It depends, right? If there is some kind of emergency,
right, like a flood or something, right?
Yeah, then they have a right to come in. Otherwise, no, you have a right to your enjoyment of the home. And that's one of the things that you have. So when we talk about two cases today, you're going to also see that distinguished. So you basically have gotten a lot of the rights and obligations of the tenant. Now, if the roles were reversed, if you're the landlord, what do you have to do as the landlord? What are you expecting to have done? I'll give you an easy one. You're expecting to, Anna, hold on. Good. Hold on to that thought. I want you to say it out loud. You're expecting that the tenant is going to pay you, right? What else? Anna, whatever you wrote, you want to say it out loud?
Yeah, the home has to be livable or habitable, like
Yep.
somebody else said. Like I cannot have any pests or
Yep.
mold, for
Yeah.
example, that would affect my health.
That's right. Exactly. So when you are the landlord, you have to make the place, and I think Tanisha also hit it on the head. You have to make the place habitable, right? You have to have the common areas free from defects. Okay, so you want to make sure that the place, if something is, let me ask you this, because I want to see how your noggins are working. If the microwave breaks in the apartment, does the landlord have an obligation to fix it?
Yes.
It depends.
It depends if it was provided by the landlord.
Exactly. It depends. Some of these questions I ask you are not straight up right or wrong. It depends, because it depends on whether or not it was part of the lease agreement. If you were provided with a home that had a microwave, that they gave it to you to use, and then it broke, the expectation would be that the landlord would fix it or provide you a new one. If, however, it's the microwave you brought with you, the landlord does not have an obligation to fix it. But
I have a question, Professor.
Sure.
If it was provided by the landlord, the microwave, but
Yes.
you did something stupid to break it, and maybe it was like kind of even intentional, is it still their responsibility?
No, it's not. No, it's not. And that's why you'll see, if you've ever entered into a written lease, it's, I think maybe even somebody put it in the chat here, it's about basic wear and tear, right? So if you have somebody that intentionally caused damage, they're going to have to pay for it. What do landlords usually ask of tenants before they move in? To pay what?
Security deposit.
Security deposit, right? Because if you break or damage something, it comes out of that security deposit, so you lose that money. So that way you are more careful about what you're doing, because it's, otherwise you're going to lose that security deposit. And usually that security deposit is about 1 month's rent, right? So good. Who wants to tell me, you guys did very good with this, who wants to tell me about home rentals versus Curtis?
I could tell you a little bit about it.
Go ahead.
So I'm pretty sure it was a bunch of kids. I think it was like, or guys. There were 4 guys, I think, and they signed a lease.
Mm-hmm.
And once they paid the security deposit, and I think they paid 2 months advance in rent.
Right.
And then they arrived at the house, and they ended up finding a lot of problems with the house. Like there was bugs everywhere. It was unlivable. Like there were so many things wrong with it. They said something, like they reached out to the company. The company said, fix them and then we'll reimburse you. They tried fixing them, like the roaches. They tried to get the roaches out. They even called an exterminator to help. It didn't work. So the boys moved out. And they reported the conditions, and the company had to fix them. The company ended up fixing them, but after fixing them, instead of leasing it out, they went after the boys for the rest of the rent that they owed, because they had a lease for about a year.
Right. Excellent.
Yeah.
Very good. Excellent. What did the court say? Do you remember who the court sided with?
Didn't the court side with the boys?
Yep, exactly. Perfect. You did a great job. The reason was, this wasn't a simple case of, oh, when I put down my deposit, the place was 74 degrees and now I moved in and it's 70 degrees and it's not, working. The place became inhabitable, which means it was not fit for living. So as a landlord, you have to provide a habitable place for living, free from rodents, free from insects. Look, ants, fine. Just because you have a few ants doesn't mean that you can withhold rent. But if you have an entire infestation of rodents, you have holes in the walls. I think that was also one of the things. you can't live there. If you don't have running water, you can't live there, right? You can't enjoy. You need quiet enjoyment. It's a legal term, right? You need to be able to enjoy heat. You're supposed to have heat also. You're supposed to have heat. If the boiler breaks and your landlord is trying to fix it, they're taking those active steps, then that's fine. But if they're like ignoring your calls and it's 1 week after 2 week after 3, and then you don't have heat, then that's something, a reason where you could withhold rent, because the basic things that are supposed to be provided to you are not. You've often heard of like slum lords, right? People, building owners that have these buildings in these, abhorrent conditions, that are not fixing it up, that basically are just renting it out. And yeah, like the bad landlords. People can go after them, right? But what happens? I want you to think now real life. If a tenant goes after the landlord does what? They usually
Kicks them out.
kicks them out. And so sometimes the person's like, there's no other apartments, I have nowhere to go, so they deal with the bad conditions. It doesn't mean that that's right, but that's the reality of life. So home rentals is a case I usually ask on, so make sure that you know it, and just know the differences between, if you're a tenant and you're a landlord. Very simple stuff, nothing crazy here. One of the other, yeah,
Sorry.
no, go ahead.
So I think the law in New York is more on the side of the tenants more than the landlord even.
Yeah,
Like
in New York
honestly,
it
I
is.
know people who host like my whatever who I work with. They have people who hold the rent for very stupid stuff like something a light bulb or anything, and we're talking about maybe a rent of $3,000, and they even like keep sending those text messages like as if everything documented, kind of a threatening as well, like of suing for those stupid stuff. So
Yeah, that's
you
not
really have
actually
that right.
something, you're not like, you can't withhold rent for something stupid like a light bulb. And if you go to court, you're not going to win that argument, right? It's not. The problem is, again, in reality, in real life, is as a landlord, you, generally speaking, as long as you're not a slumlord, you also have a mortgage to pay as well. So you need this rental income so you can pay your mortgage. Look at everything that's happened with COVID, right? People, tenants have lost their jobs, right? So they can't pay. They're not paying the landlords. The landlords are not able to take them to court because a lot of the courts have shut down, and there was a moratorium on actually, going through with foreclosures and things like that. And the landlords are dying because the mortgage companies are not forgiving, right? And even if they were to allow them, 2-3 months where you don't have to pay, well, you're going to eventually have to pay, and you're going to have to pay with interest. It's not like that's going to be going away. So you have this battle, and it's hard. And New York is a tenant friendly state, especially if it's a family that lives there, especially if they have kids, right? And the landlord at some point will be like, just give me something, just get out. And then so it's a very difficult struggle. But then you have a family who knows if they get out of this apartment, it's going to be very difficult for them to find something else. So it's hard really on both sides. So it's not a good situation to be in. There's something I want to make sure that I tell you, because I don't want to forget to point this out, and that's the difference between assignment and sublease. Okay, this is something I want you to know. The difference between an assignment and a sublease. If I'm the landlord, Danielle, I'm going to use you as an example. Danielle, you are my tenant. You just signed a lease for 2 years. After 6 months of living there, you got a job in California. If you want to assign your lease, what does that mean? Do you know? If you don't, that's okay too.
I don't know if you called on me, but my computer froze. So
Okay, I did. Do you know the difference, or do you know what an assignment is?
I heard bits and pieces, but I feel like it's like if you know you're gonna work somewhere, you could be like, I know I need to move in from April because that's when I start my job. Maybe something like that, like April to
No, you were my tenant and now you have to leave. Actually, Tanisha actually got it. So that's good. You're off the hook, Danielle. So assign someone else to live there and pay rent. Tanisha, where are you? I do not see you. So I just only see your chats. But if you want to say it out loud, because now I'm going to ask you a further question. What's the difference between an assignment and a sublease? Because you're on the right track.
I think a sublease is like when you are signing the lease, you have somebody else to take over if you do try to leave, or no?
It's actually the other way around.
Okay.
So
okay.
in an assignment, you did great. In an assignment, somebody else steps into your lease agreement. So with an assignment, I'm going to actually use my little dandy whiteboard here. So if you have, let's say A and B enter into an agreement. A is the landlord, B is the tenant. B has to leave to go to California. All right. If B finds another tenant, C, to step into the sublease, if B assigns the lease to C, the relationship now becomes A and C directly. B is out of the picture. So it's as if A and C entered into an agreement together. So an assignment is the new person steps into the shoes of the old person. They take over the lease in its entirety. The relationship is now with A and C. In a sublease, hold on. In a sublease, the relationship remains between C and B. So C has to continuously pay rent to B, and then B maintains the relationship with A. So a sublease, B is still responsible. With an assignment, B is completely out of the picture. So
question.
Go ahead, yeah.
With an assignment, does that mean like there's a legal lease changed and everything, new names?
Yep.
Okay.
C steps into the shoes of B.
Okay.
Hold on, let me stop sharing. Okay, so that's what that is. And either one cannot be done unless you have permission from your landlord. So you will see in the lease, a lot of times it'll say you cannot sublease, you cannot assign without the landlord's permission. Why is that?
Because not all the time that person might pay their rent.
Yeah, that's right. You have somebody new coming in. It's like if you're renting to somebody, you're doing a background check on them. You're making sure that this is a person you want to live in your home. So B can't just have somebody that they know without letting the landlord know. So say that again?
Is it like re-renting, like you're
Yep,
renting something
exactly.
Like you
Exactly. So you need to have the landlord's permission in order to do that. Very good. Let me see what else I want you guys to know. Tenancy. Also, if you're renting to somebody and they're going to be there for more than 1 year, it's a contractual agreement. And again, we're going to spend a lot of time on that in the next third. But if it's more than a year, you have to have that in writing. If it's less than a year, it's considered a month-to-month tenancy. And so if it's a month-to-month, you don't necessarily need to have it in writing. Is it a good idea to have it in writing? Yes. Why is it a good idea to have in writing a lease agreement?
Can be documented because everyone forget. So
exactly.
You don't want to go through the bottle that who said this, who said they,
Yep.
be responsible. Yeah.
That's right. When you have everything in writing, it just puts everybody on notice. That way they know what each person's responsibilities are. If you put everything right at the onset saying, all right, you're allowed to have pets, no smoking, rent is due on this day. If you don't pay, exactly, you're protecting yourself. You're putting everything out there in the beginning, letting them know. That way you don't have a problem later on, because a problem happens when there's a disagreement. So you want to try to avoid that as much as possible by thinking of as many contingencies as possible and making sure the person who's renting from you understands that. Let me see what else I want you guys to know. Blah, blah, Tenant. Okay, we talked about that. We talked about that. Okay, we talked about that. Hallways, elevators, lobbies. Okay. Who read Tucker versus Hayford and can tell me briefly about that case? I don't usually test on that case, so it's a listening
Not on
one.
the syllabus.
Huh? I didn't put on the syllabus?
No.
Okay, if I did not put on the syllabus, then you guys don't even have to know
I have
it.
your syllabus on my other screen, so
Yeah, no, I have it on my screen as well, but I have it in my notes. I used to, let me tell you, like I said before, this COVID really has, I've really, I don't want to say watered down the material, but I've taken out a lot of stuff. So I expect you all to get A's, honestly, because I mean, it's so easy now, the material that I give you. All right, so you don't have to know that one. It's about water, actually, just drinking water, but that's fine. So the next thing we're going to talk about is also with real property, but it's the different types of ownership when we talk about real property. So we talked about renting. Now we're going to talk about owning. I'm going to give you my screen here. Okay, let's clear this up. Okay. There's 3 different types of ownership that you can have with real property. So let's say A and B are purchasing this house. A and B are brother and sister, or 2 brothers, or 2 friends. They each own an undivided 1/2 interest. It doesn't mean that A owns the left and B owns the right. They're actually considered something called, where's the text? Can't do it. Tenants in common. As tenants in common, that's the default. So if we don't have the other 2 things I'm going to talk about, when people purchase a piece of property, if they don't have the other designations, the default is they're tenants in common. And what that means is each of the owners owns a undivided 1/2 interest. Again, it's not like it's I own top, you own bottom. It's I own 1/2 and you own 1/2. So if we were to sell it, I get half, you get half. What happens is also that you need to know is what happens if they own it as A and B and A dies? What happens to A's ownership interest?
it goes to whoever gonna inherit him as a tenancy in common as well.
It goes into, so somebody wrote B takes over. No, it's actually not. So it's what Amar said, it flows into A's estate. So if they own it as tenants in common, A dies. If A leaves, if A had a will, it goes to whatever according to that will. And if it doesn't, A did not have a will, we're going to talk about that stuff too today, then it goes to their next of kin. And so now B may end up as an owner, possibly with somebody they have no idea who this person is or have never met. So that's tenants in common. The next one we're going to talk about is tenants with rights of survivorship. And again, we're going to still go with A and B. What is the most common thing? Do you know what tenants with rights of survivorship? If you wanted to take a guess, what do you think tenants with rights of survivorship would mean?
When one of them die, the other one takes everything.
That's right. It's like it's the biggest gamble that you would take, right? So if you just outlive the other person, you get the entire thing. What is the most common relationship that you think would necessitate or have people actually choose this as a type of designation? Because I have my whiteboard, I can't see. Somebody wrote family. Not husband and wife. You're going to see that one as actually the next one. But what besides husband and wife, what else do you think it would be? You said
Parents
family.
and children.
Huh?
Parent with the children.
Yeah.
Or with the
The
child.
most common one is a parent with a child. So mom will live with B, and as long as B survives or outlives A, they'll be able to get the whole thing. So that's tenants with rights of survivorship. So we know that as soon as one of them dies, the other gets it. So now the last one that we're going to do is also A and B, but it's going to be tenants by the entirety. And that's the one where it's married people, married couple. And that one also has the same thing where if it's A and B, right, they own it. If one of them dies, the other does get the other half or gets full ownership. But this is a write it down moment. When you own something as tenants by the entirety, it protects against creditors. So a creditor can't come after you if this is the marital home. So this actually is the best way to protect your home. Usually for most people, owning a home is their biggest asset. So if you own it as tenants by the entirety and somebody wants to sue you, if it's the marital home, they usually cannot attach any liens against that. So it's a good way of ownership. And again, if one of you dies, the other person owns it. I know something came up in the chat. Let me see here, because I want to talk about divorce. Siblings. How would you set it up? Okay, so we're going to go into siblings and then the IRS. The IRS can do anything that they want. It's not a regular creditor. They will get you. So they will attach to your home, your bank accounts, they will seize your cars. They are no joke. So that's the IRS. As far as siblings, give me more as far as what you're trying to say. Like you want them to own a house together, a bunch of siblings, or what's, give me more on the question.
So what I mean is, Professor, like let's say I get a house, right?
Yeah.
Let's assume I'm married, right? How would I set it up as like tenants by entirety? Would I do that in a will or a
No.
lawyer or?
Usually when you're buying the home, like when you're doing the closing, if you're married at the time of closing, your lawyer would put that in the deed.
Okay, so let's say I buy the house, but then get married later on. How would I go around it?
So at that point, it's your house completely. So you would need to go to a lawyer so the deed can be transferred from you as an individual owner to you and your spouse by tenants of the entirety. If any of you own homes or, your parents own homes, ask them to take a look at the deed. The deed, the first few lines will say how a piece of property is actually owned, whether it's tenants in common, tenants by the entirety. It'll say sometimes, it'll have the designation, it'll say husband and wife on it, and that would, it would be inferred that it's tenants by the entirety when they write that in there. So it gives you that protection. Does anybody else have any questions? Because I want to give you the attendance phrase for the night before I move on to the next chapter.
You said you wanted to say in case of divorce.
Oh, yes. Thank you. I forget things. Okay. So what happens if husband and wife, they own it as tenants by the entirety and then they get divorced, but they are still, what happens to the house?
They can divide the house now in between them physically?
It's what somebody else said something.
Wouldn't it get decided in kind of like a civil court in the divorce?
It could be, yeah, absolutely. A divorce court and then Supreme Court, and then they would decide who gets what. My son, my 7-year-old thinks he knows. Yes.
I think the divorced couple sells the house and each gets half.
It could be if it's part of their stipulation. Thank you, Christopher. It could be if it's part of their stipulation. Sometimes one will get it over the other. Let's say it's an amicable divorce and they still want to reside there. If their relationship has now deteriorated and ended in divorce, it actually defaults to tenants in common. He's not. He just seems that he is, Anna. Don't worry. He speaks like he's 50 years old. So that's that. So if a designation changes, the default is it goes to tenants in common. So now I will tell you my, let me just go into my attendance, my secret phrases so we do not forget. Okay, today is February 22, 2021. Attendance on Monday. All right, the phrase for tonight is, I like to knit scarves in my spare time. I like to knit scarves in my spare time. One more time, this is attendance for tonight, 222. I like to knit scarves in my spare time. Okay, I'm going to move on now to the next topic. Okay. Co-ops. We talked about co-ops earlier. How do you own a co-op? I want to see who was paying attention.
By owning shares in the corporation that owns the land or the building.
That's right. It's just ownership of shares. So when one of the owners in the co-op dies, their shares just get passed on as if it was personal property. So if they had a will, it would go whatever the will said. If they didn't have a will, it would be distributed according to the estate. And again, we're going to talk about that later. We're going to talk about it tonight as well. That's all the stuff. Let me just look at the syllabus. Tenants by the entirety. Okay, that's all the stuff I want you to know for chapter 48. We're going to move on to chapter 49. We have 49 and 50 left to go. 49 is, again, we're still dealing with property, but now we're going to go into a little bit of detail as far as how to actually transfer the property. Remember when I was saying earlier that, you know, if you're transferring personal property, it could be as easy as, you know, you're selling it, you're trading it, whatnot. But when we have real property, it's a little more complicated. When you are transferring real property, it cannot be done by an oral agreement, and you have to have that in writing. And at the very, very minimum, you have to have these 5 things. I'm going to put it in the chat. Okay. So when you have an agreement to sell real property, you must have these 5 things. They're the names and addresses of the parties, a description of the property, the time for the conveyance, which is the closing. You've probably heard the term closing before. The type of deed, what we just spoke about. It's whether it's tenants in common, tenants by the entirety, or joint tenants with rights of survivorship, and the price and manner of payment. How are you going to pay? How much is it going to be? That all has to be in writing. Now, usually a deed or the transfer documents are a lot more than that, but that's the very, very minimum of the items it actually must have. When you're also transferring property, let's say you bought a new house. Congratulations, right? Who actually owns this house when you first buy it?
If you got a mortgage, it's the bank.
That's right. If you have a mortgage, it's the bank, right? So the bank is actually the owner until you finish paying off the mortgage. Then you become the owner. And so the bank has an interest in that house. They usually do reports. So before you actually even purchase, they're going to come in and they're going to do an appraisal of the property to make sure that you're not overpaying. Why? Because it's an investment that they're in fact making it. And the bank doesn't want you to default on the house. They don't want a house. They just want you to have the pay the mortgage so they can get their money plus interest. That's how it works. What else do I want you to know? When you also buy a home, what happens if you buy a house? Has anybody here ever purchased a piece of property?
I kind of just hear about it. I still didn't do it.
Okay, that's okay. So when you buy a piece of property, you usually get an inspection done. An inspection, you usually would pay for it as the purchaser, so it comes out of your pocket. But why is an inspection a good idea?
To see if there's any defective stuff in the house, so you can either devalue the house or ask to deduct it from the house, or even the owner fix it before you buy it.
Yeah, you basically want to know what you're getting yourself into. Now, what
And
happens? Yes, somebody was saying something.
sometimes the people who are selling it aren't like upfront and honest about certain things that you can't physically see with your own eyes.
Exactly. You want to know what's happening behind those walls, because behind those walls could be something, major damage that you're not aware of. So you always want to get an inspection. What happens if you buy a house that's in as is condition? If you buy a house as is, what does that mean? If you've ever looked at Realtor or Zillow,
Everything. You can accept the house as it
wait,
is.
Amar, hold on one second. Amar, hold on. Say that somebody else was talking.
I was gonna say that pretty much however the house is sold is what you have, and if you want to make any improvements, that's specifically on you.
That's exactly it. So when you're buying something as is, that you get what you get and you don't get upset. Like that's you're getting that house, whatever's wrong with it, and usually it's at at a reduced rate. So it doesn't matter if you get an inspection, you find out all the stuff is wrong, like this is it. The seller is not making any type of warranty as to what the house is. They're not making any warranty saying that this is going to last you for the next 50 years. Once you buy it, that's it, it's yours. If you buy a brand new home, yes, like lemon cars, exactly. Once you buy a brand new home, Thomas, do you have a question?
Yeah, quick
Go ahead.
question. If you just bought a house, you're allowed to do any type of changes that you want to the house. You can do anything you want.
So it depends. It depends on the type of ownership you have, and it depends if you have some kind of association. So if you've bought a house in an association where there's 5, 10 houses, whatever, 20, whatever that number is, and you have to pay like a monthly fee for something, some of these associations have rules as to what you can or cannot do. So they want the lawn to be a certain way, or you can't have a particular flag up, or you cannot have any decoration on the front wall, or you can't have any lights. But if you own a home that's totally yours, ownership, you don't have any association or anything like that, yeah, you can do whatever you want, as long as you're not harming or you're not doing anything that's going to impede the enjoyment of your neighbors. So if you decide to put a tower of a satellite tower, so for AT&T in your backyard, your neighbors may have a problem with that, even though it's on your land. But if you want to put a swimming pool, that's on you. It's going to be in your land as well. Condos and co-ops, super, super strict. I live in a co-op. We can't even put Christmas lights outside. We're not allowed to. There's bushes, but you can't use them. You're not allowed to do that. So you can put whatever you want inside your apartment. You can't do it on the outside. So it depends on where you live. Any other questions? Okay. So when you buy a brand new house, it comes with certain warranties. So the warranty will say, generally speaking, that the house is free from defects, meaning the plumbing is going to work for X amount of years. The structure of the home is going to work for X amount of years. You're not going to have any, wiring problems, electricity or whatever for X amount of years. Once that time is up, now you're on your own. Anything goes wrong, it's you to fix it. That's usually just with new homes, not regular ones. Anybody questions before I move on? Okay. What's a foreclosure? You've heard the term. What's foreclosure?
When somebody can't pay their mortgage for X amount of time, and then
right.
the bank takes over the house, and it's
Exactly.
up to the bank who it goes from there.
That's right, exactly. You no longer, because don't forget what we said a little while ago, you don't actually own the house, right? It's the bank that owns the house with you. And so you still have to pay the bank. If, month after month, X amount of time has passed and you haven't been able to pay your mortgage, they can actually take over the house. The house then becomes theirs. And then they can sell the house to anybody and they can try to recoup the money that they are owed. So that's a foreclosure when you no longer own it. What
And
about
that's actually the best kind of homes to buy, right? Because they're very inexpensive and
yeah,
they usually
yes, but they're usually like what happens in a home where the owners now still live there, they're not paying, and now they're pissed off because they're losing their home.
Wait, isn't there also a thing where like sometimes they physically cannot kick the people out?
Well, right now you can't kick anybody out, but that's not always the
like
case.
a squatter or something.
A squatter is different. A squatter is somebody who's there that is not supposed to be there. But in a foreclosure, it's the owners who are still living there. And now, if now the bank takes over, there's people that live there. What are they going to do before they leave?
Break the house.
They're going to destroy the house, right? They're going to damage it. Why? Because they're not happy. They just lost their home. They lost their life savings. Again, don't forget when somebody buys a house, they're putting a down payment. It's their home and now they're losing it, so they're not exactly going to be happy. So sometimes they will damage the house. It is usually going to be cheaper. Why? Because it's a foreclosure, but again, you don't know what you're possibly getting. And a lot of times when the bank is now selling it, they want just an all cash payment. So I people that will have all cash can get kind of good deals. Then they'll fix it up and then they'll flip it and then they'll sell it out.
Yeah, some people will just buy it for the property and knock it down and rebuild.
Then just rebuild it. Exactly. Let me see what else I have. Somebody have a question?
When the bank puts the house for foreclosure and then they put it up for like the auction, are they asking like what the whole house is worth or like what the what they owe on the house, I guess?
Yeah, they usually will start with the asking price would be how much they're actually owed.
Okay.
And then people will bid up because there's public auctions for those types of houses. So then it's like they'll go up. So it may not be the actual value of the home at that particular time, but it'll be as long as the bank gets their whatever they're owed, then they're happy.
People don't have the option to sell it before they go.
They do, absolutely. So there are other avenues besides foreclosure. Foreclosure is usually a last resort when somebody that just can't make the payments anymore. There's something called a short sale. There's a short sale or a deed in lieu of foreclosure where you just say, listen, I'm going to just give you the house. I'm going to walk away from it. I'm not going to damage it. And then you forgive me the loan, because what happens is if you do have a bank, a foreclosure against you, oftentimes your credit is now ruined for like 7 years. And so you're not going to be able to make any other purchases for that long period of time, and credit is important. So you may not want to have a foreclosure. You may want to do that deed in lieu or a short sale. Or you may try to refinance with the financial institution. So foreclosure is really like a last resort, but there are other options. So the next thing I want to talk to you guys about is a legal theory, and it's a fun theory. It's called the theory of adverse possession. And I always tell classes this. I have not had anybody that has actually taken me up on this. And again, let me be clear. I'm not recommending you do this. I'm not even suggesting you do this. I'm just saying this is a legal theory that exists out there. And what this legal theory says is, let's say you see an abandoned home. There's a bunch. If you're from Staten Island, you know there's abandoned houses like all over the place, right? So let's say you find an abandoned home that you like. You go in there, you clean it up, you make it your own. You put your lights, you get National Grid to supply you with the energy and gas, and you know, you put your curtains up, you get your mail delivered there, and you make that place your own. If you can openly and notoriously claim it as your own for 20 years, 20, that's the theory, that's the legal theory, then that house is yours. So you didn't pay anything, you fixed it up. But if less than 20 years, if after 5 years or 10 years, the actual owners, whether it's the financial institution, the bank that owned it that was not able to sell it, or the heirs that, you know, second cousin once removed comes and is able to prove that this is their house, you actually have to get out. But it's a chance you take. So I always tell students, if you ever decide to use the theory of adverse possession, and you become successful in owning a house that way, please let me know. So I've been doing this now at CSI for about 5-6 years. Maybe in another 14 or 15 years, I will let you guys know, future generations, whether or not somebody actually used it and whether or not I was actually successful. So that's the theory.
Can the family of the heir sue you?
Yeah, they can, because it's not your house, but you're openly and notoriously claiming that it's your own. So how do you show that? That's why you have to have your mail delivered there. You have to, it's not like something you're hiding. You have to be able to show that you're living there and let it be known to everyone that you live there.
Yeah, if you have like 2 bills in your name, I mean, that's your house.
That's it. That's it. So that is the theory, young people, of, I know that would suck, 19 years and then the real owner shows up. Yes. It's an interesting theory. I've only seen it once where somebody tried to actually claim it in a court of law and they lost. It did not, because it wasn't, they were nowhere near like the 20 years, and it was on Staten Island. It was, again, you might be the daughter or the son of the person who tried to do this. So I will just give you the facts. So it was a semi-attached home on, like, I think Father Capodanno. One side was owned by a very old woman who died. And after she died, her next door neighbor decided to make that house her own and started renting it out to people and collecting the rent. So the public administrator got involved, and the public administrator is an entity, a city agency, that when somebody dies and they do not have any heirs at law, the public administrator kind of steps in so they can like administer their estate. So then the public administrator found out what this person was doing. She ended up getting a lawyer, and the lawyer tried to use the theory, amongst others, of adverse possession, but that did not hold any water. First, she was like, oh, she gifted to me. She told me before she died. She gave it to me in the will, all that jazz, but it didn't work. Somebody put an article in this thingy here. I'm trying to pull it up. A man who gained notoriety for claiming he could live in a 340,000 suburban house for $16 has vacated the home following a judge's order. Yes, affidavit of adverse possession. That's right. In May of 2011. See, look at that. Squatters' rights. Very good. See, these things does happen. Very nice. And you have to that's right. You have to live there continuously. So there are some people who do try it. If you do try it, please let me know. Just reach out to me at my email. It probably won't change, 20 years from now. So just let me know. I'd be curious to see if it actually worked for any of you. So that's adverse possession. Don't worry about eminent domain. I don't even know if I put that on your theory, if I took your syllabus or I took that out.
I have a question, actually.
Sure.
That's like, it's kind of related, but not really.
Okay.
My friend bought a house, and she found out that her neighbor has some of her property, about like 2 yards or something of her property, or 2 square feet, whatever it is, 20. And is that technically his property because he's been living there for more than 20 years?
So
Or
it depends on how
them?
It depends on how if they have been using it openly and notoriously for 20 years and all the previous owners had not, and again, let me just start with, I'm not giving you legal advice, or your neighbor or your friend or whoever. But if they have been using it, it's not so much adverse possession. It could be a theory of, there's actually another legal theory where you it's not eminent domain, it's
like a grandfather in kind of thing.
they're grandfathering in that particular section, and so then it becomes kind of theirs. But if there had been disputes in the past, like I don't know how long your friend had been living there, or if she purchased it.
So what actually just happened was she bought her home, but the lady before her lived there for years, so she never really cared or even bothered to even look into it. But now my friend is building a house on the property, and she sees the property line is, cut down by a few square feet.
That's a considerable amount, and so she can certainly have a lawyer, like, hey, it's her land,
take it
and
back.
she can take it back. Yeah.
Yeah.
So because when she purchased it, the argument would be when she purchased it, on the survey that she had, I'm sure she had, it said that she owned this. So she purchased the home based on that premise. It's certainly going to cause a problem between her and the neighbor.
Yeah, definitely.
But yeah, and those disputes are always ugly, very, very ugly.
Yeah, right. And then you have to live next door.
Yep. But a lot of times, when it's like a fence and it's just a couple of inches or 6 inches or a foot, that causes problems as well. So certainly a few feet, oh, absolutely. Yeah.
Yeah, especially when she's building her home from scratch, any land counts.
Exactly. Land absolutely counts, and land is very expensive on Staten Island.
Yeah, it is.
Okay. So that
Thank you.
takes care of, oh, you're welcome. My little boy was out, and so he just came home, so you might hear my 3-year-old now. They're actually embracing, which is very nice. My kids, that's lovely. You don't have to bring him. He doesn't have to see people. Okay, fine. Thank you, Christopher. Thank you. Okay, so we're gonna go on to the last chapter of the evening. Hey, baby. Thank you. Okay, so the last chapter is chapter 50, and chapter 50 talks about, I love this section. I love this section. Why? Because it's what I do for a living, and what I've done for a living for a very long time. So this is when we're talking about estates. And I love this. This is an area that you need to kind of understand. I'm not going to go into trusts so much, and I think I might have even taken that out of your syllabus as well. We're actually just going to talk about wills and administration and that sort of thing. So the best way to actually do it is I'm going to give you, I'm going to do that whiteboard again, and we're going to have a couple of scenarios. The way we're going to break it down is what happens when somebody dies with a will versus what happens when somebody dies without a will. So we're going to do here, let's do will, which means it has to be probated. So and then we're going to have here where it's administration, intestacy. I'm just using vocabulary that means these things. No will. Okay. Let me just move this over so I can actually see it. Okay, I cannot see it. Okay. I've minimized you people, so like the little screen with all your faces on it. So if you have something to say, you're gonna have to say it out loud because I'm not gonna be able to see it. So when we talk about a will, and we're gonna have a family, it's gonna be the same family, and I'm gonna show you how the money is distributed. We're gonna have a husband and a wife and 3 kids. So and we're gonna have an estate of $100,000.
Should we write this down or?
Right now, I think try to understand it, and then I'll give you a couple more examples, and then those you could write down.
Okay.
So if we have a will and we have the husband die, and the husband owned $100,000 in his name alone, and he had a will, the will would designate who gets what. So it could be the wife gets the entire 100,000. It could be the 3 kids. It could be a charity. It could be whatever. The will designates how the assets are distributed. The only thing that's important to know in a will is you cannot, let me repeat this, and this is something you can write down, cannot disinherit a spouse. And this is based New York stuff, okay? So let's say the husband died, he hated the wife. They only stayed together for the kids. and he leaves the entire $100,000 to his 3 kids, the wife can actually file something called a right of election, and she's entitled to 1/3 of the estate. So if she's entitled to 1/3, how much does the wife get? Based on this estate, how much does the wife get?
25,000.
25?
33.
33,000, right? Because she's getting 1/3. Now, how about the 3 kids? How much are they going to get?
66.66.
Correct. So all 3 of them are going to get 66.66, and that's going to be divided by 3. So 66.66 divided by 3 is 22.22, right? So that's what happens when you have a will. The will dictates who gets what, but you cannot disinherit a spouse. There's a little more to it, but I'm going to just give you the simple version for now until you have an understanding, and then we're going to have different permeations. If, however, there is no will, still have husband and wife, 3 kids, and $100,000, the way it works is there's actually a formula. We're going to still kill off the husband. So here, what we're going to have is a formula. The surviving spouse, and this is New York law, surviving spouse gets first $50K plus half the balance. So if that's and then the kids get other half. So whatever that balance is. So in this situation, how much would the wife get?
75,000.
75,000. How did you get that?
50,000, and then the left is 50, half of it 25, so 75,000.
Right. And now the kids are going to get the balance, right? That's 25K.
25 over 3.
That's right. Divided by 3. So that's the balance, 75,000 and then 25 divided by 3. Do you guys understand the differences here?
Just in the first case, if there is a will, they just and he didn't disinherit the spouse, so they just divide it according to the will. There is no the third.
Correct. If he doesn't disinherit the spouse, a lot of times what happens in a will is you usually give your spouse the entire thing. So if I die, I'll give my husband everything I own because I'm going to assume he's going to take care of the kids. And then when he dies, then the kids will get everything. So you only my husband's making jokes now. The 1/3 comes into play only if you're disinheriting the spouse. I know that there's like the light thing is coming on for the chat, but I really can't see it because I have it minimized so I can see the screen. So if you have something to say, you have to say it out loud. So those are the 2 things. I'm going to now give you a couple of other examples. So now you can kind of write things down. Let me just see if I can. Let's say it's not 100,000. Oh, I don't know how to do this. So I'm going to just clear it. Okay, clear all drawings. So now I'm going to give you an example. Let's say we have wife only, just say woman, 4 kids, 3 are adults and 1 is a minor. Mom dies with $200,000 in her name alone. How much do the adults get? How much does the minor? You have to say it out loud.
Each gets 50 regardless, adult or minor.
That's correct. It doesn't matter if it's an adult or a minor. They share it equally. The minor just may not be able to get his money outright. It may be held in another vehicle, like a guardianship account. I'm not going to ask you about that, but the kids can share it equally. Let's say the next example, this is an administration, okay? So we don't have any wills. Next example is Mr. Man dies, no spouse, no children, leaves 100K. Who gets that 100,000?
His siblings or his mom? Maybe his sibling? No, maybe his mom.
Anybody else?
Either way.
It goes first to his parents if he has ones. If not, it goes then his whatever comes after.
It goes, so this is now where we're going to get into the rights, like the actual inheritance rights. So the law says that when somebody passes, it's the spouse first and or kids. It's sometimes a separate class. If there's no spouse, then kids. If there's no spouse and no kids, then it's the parents. So in this particular example that I just gave you, the parents of the person who died would inherit. If it's one parent that's alive, that parent gets the whole thing. If it's two parents that are alive, they share in that. It doesn't matter if those parents are divorced or married. Only if both parents are dead, then do that original dead person's siblings get. So
And
it's
this is all with no will?
correct. This is all, yes, that's absolutely correct. This is what the law says if you don't have a will.
Perfect. Thank
Because when you do have a will, it's the will that dictates who gets what. Okay?
And what if there's no parents or no siblings or
So
no
then
children?
it actually, it's the whole pecking order. So you have a person who dies, we look for their spouse, we look for their children, we look for their parents, we look for their siblings. Then we go back to parents and then uncles, like uncles and aunts. So those parents of the dead person, their siblings. There's a whole pecking order for purposes of this 100 level class. You only need to know as far as the deceased person's siblings. Okay? So you have to know that pecking order, because I'm going to ask questions and I'm like, so-and-so died, they're survived by this, who gets what? So you have to know if they're entitled to share or not. Let me just see my notes here, see if there's anything else I want you to know about that. Okay, when we also talked about wills, right? That will is not, just because you have a will doesn't mean that whatever's in that will is actually going to happen. It has to go through the court. So, and this is, I mean, I've done this for a number of years, and Staten Island is like a gigantic soap opera. So I will tell you this from experience. What happens is if somebody passes away, right? And let's say mom lived with her daughter. They had a house, joint tenants with rights of survivorship, and mom also had like $500,000 in cash. Mom had a will that left everything to that one daughter, but mom also had 3 other kids. So she had a will that leaves everything, $500,000, let's just stick with the cash, to this one particular daughter. Does that mean that daughter automatically gets it?
I feel like yes.
It's not an automatic thing. That will has to be proven. And those kids, those other 3 kids that just got disinherited, they have the opportunity to try to knock that will out. So
how do you prove a will?
Oh, there's ways to do it. I'm about to just get into that. So when you have a will, you must prove the following. I'm going to put this in the chat. You must prove, number 1, that the person who died had testamentary capacity, meaning they had the mental wherewithal to have this will. You have to prove that it was duly executed. There's due execution. That's the actual title, due execution, meaning it met all the rules established in the state. And I'm going to get into that in a second. So it means it has to have been done properly. There's actually a right way to do a will and a wrong way to do a will. You have to make sure that there was no undue influence or duress. And number 4, no fraud. So if somebody's trying to knock out a will, They're going to say, mom did not have the testamentary capacity. Mom was on a bunch of medications. She didn't know what she was doing. You know what? That will wasn't done properly. This was done wrong. This was done wrong. This was done wrong. You know, it's my sister. She got into her brain. She didn't let her see any of us. She totally excluded her from us. Mom didn't know that we loved her. Mom kept her away from us.
How could you prove any of that though?
Oh,
really?
you can prove. Oh, let me tell you, we have that. That's why you have discovery in the courts. So there's a whole process of you ask the witnesses to the will, the drafting attorney, you get statements, and this is a trial, and we've had this. There's a case I will tell you, and this was actually covered in the Staten Island Advance a long time ago. It was one of the first cases that I ever worked on. And there was a man, he was married, he had 2 children. He also had another woman. From this other woman, he had a daughter. Wife finds out about this other woman and this daughter. She tells the guy, and he was a prominent builder on Staten Island. She tells him, I'm not going to go through this. You either move out or you're going to stop this and you're going to do a will that names me as the beneficiary and our children. The guy moves out. He lives with his brother for a while. He finally decides to go to a lawyer and he does a will. And he names his wife as the beneficiary, and everything, if she dies, everything goes to his marital children. When he dies, his other daughter, the one that didn't get anything, she tries to throw out the will. She says it wasn't duly executed. He didn't have testamentary capacity. And how do you prove testamentary capacity? You get medical documentation, right? To show whether or not this person was on medication. Did they know what they were doing? Were they lucid? Were they not? But the main thing that they tried to do was to try to show that this person was unduly influenced, that the wife made him do it. The thing is, when we talk about undue influence with respect to wills, the influence has to be so great that a person cannot think for themselves. Think about an elderly person, somebody frail, when they don't know what's going on and somebody's kind of hammering at their head. I'm going to do this to you. I'm going to do this to you if you don't do this. That's undue influence. This particular case, it wasn't undue influence. It was just regular influence. It was a wife telling her husband, you either pick me and our kids or we're done. He chose his wife and his kids. So the other daughter got nothing. It all went to the wife. There's another case where a woman had 5 children. 2 of her sons were felons for manslaughter. They killed people. They served time in prison. When they got out of prison, they took mom to a lawyer and they told mom to do a will where she left everything to them, to the exclusion of the other siblings. Mom told the lawyer, if I don't leave here with a will that names these 2 kids as having everything, I'm going to get hurt. They're going to hurt me. So mom did a will that named everything to her sons. Now she died, so all the other siblings now were contesting this. That's duress. Her life was in danger, and that's why she did this. So it's witness testimony. It's medical records. It is testimony of third parties. And it's how these people present themselves in a trial. So there's certainly ways to prove or disprove. All right. So those are the things you must prove in order to have a valid will. Otherwise, it gets tossed out. And if a will gets tossed out, what do we have? It reverts then to administration, meaning there is no will. And then people get what they would have gotten if there was no will at all. Does anybody have any questions? That's all I have for tonight. So if you have questions, this is the time to ask. Your exam is next week. Your exam is on Blackboard. I'm going to ask you questions about intestacy. I'm going to ask you questions about the order of things. When somebody writes a will, they have to have that proper mental capacity. They have to know what they own. This is a write it down moment. They have to know what they own. They have to know who the objects of their bounty are. So you have to show that this person knew what they were doing when you draft the will or have a will done for you. You have to be also, I didn't mention this. In order to have a will duly executed, you must be 18 years or older to actually have a will. And it has to be signed by you and it has to be witnessed by 2 people. That's New York. So you got to be 18 years old You have to sign it at the end, and you have to have 2 witnesses. There's a bunch of other things that you need, but for purpose of this class, that's the most important stuff. Now, again, this is being recorded. I am going to upload it either today or tomorrow, and I'll put it on YouTube. So if you're following on, you'll get it right away, but I'm going to post it up to Blackboard, so you'll get it as an announcement. And then you can, if there's anything you have questions on, you can just watch the video again. Does anybody have any questions?
You said something about intestacy.
Intestacy. Intestacy is when somebody dies without a will. So that's just a word for, yeah.
Okay, perfect. Thank you.
You're welcome. How attendance? There's no attendance next week. So next week does not count for attendance purposes because you're going to be taking an exam. So you just pick it up. We'll pick it up the following week.
How long do we have for the exam again?
You're going to have the entire from 6:30 until 9 o'clock or 9:30. Most students will finish within a half hour, 45 minutes, an hour. So, but you'll have that entire time.
I have a question actually.
Sure, go ahead.
When you make a will and like you're in the right state of mind, but then towards the end of your life you get very sick and you're on medication, does the will still count?
Absolutely, because you're looking at the time of when it was executed. When you signed it, that's what's important.
So you sign it right after you finish making it, or right before you die?
No, right when you make it. Like you go to a lawyer, or if you're going to do it on your own, you sign it when you're making it. It comes into play. It's offered to the court when you die. You can change it at any time. So if you do one today, next week you change your mind, you can change it then. You rip it up and you do another one. How many questions? The questions are, I'm not done with the exam because I usually wait until I finish the last class, but it's going to be a minimum of 25 questions, multiple choice and true and false.
Does it cost money to make a will? Yeah, right?
You're going to go to a lawyer, yeah.
Yeah. But can you is there a way that you could do it for free?
You can do it.
Do you have a legal right?
Oh, yeah. There's no requirement that you have to have an attorney do it. But if you do have an attorney do it, it enjoys a presumption in the law that it was done properly. And so the due execution that I talked about, it's presumed it was done properly unless the other side can show that it was not. Because a lawyer knows what goes into a will signing ceremony. And so it would be assumed that it's done properly. But you can go online, get a sample will and do it. But you just have to make sure that you're doing it the right way. You can write whatever, but the lawyer will kind of tell you the contingencies. They'll talk about your estate, how you should divide it. What if you want to leave somebody out? They'll talk about the right of election. They'll talk about, there's this thing called, my brain is fried. But there's a thing where you can, interorum clause. So let's say you have rotten kids or one of them is a drug addict, right? And you don't want to actually leave them money because you're afraid that they're going to take that money and do bad things with it. You can leave them like, a very small amount of money and say, $1,000, because for them, $1,000, they can score big with that. And you can leave it to interim clause. And
say, like $1,000 a month, right?
No, not even that. That's even a trust. You can just say $1,000, and then it's like, if you contest my will, you lose that $1,000. So those are legal theories. You can make trusts, and that's where you have like somebody a trust where they can get $1,000 a month. So a good lawyer will understand what your situation is, and then will help you draft a document that meets your needs, depending on what your concerns are.
Right, and then it's probably harder for it to be broken by someone, right?
Correct. Yep.
Okay.
And you would just leave this, like a copy of this will with like your lawyer?
The original. You leave the original with your will, because and that's actually, I don't test on this, but it's good that you brought this up. So the original will, most people leave it with their lawyer. And then what happens is they give a copy to the person who they want to name as the executor, the person who's going to be in charge of the estate. And they tell them, my lawyer has this. And then the lawyer will then probate it, or when upon their death, then they get the original, and then they have to file to the court and they have to do all this other documentation. But the thing is, like, if the lawyer loses the original will, they can write an affidavit and explain that it was with them and they lost it. If the original will cannot be found and it was in the possession of the person to have had it, the law presumes it was destroyed, meaning revoked. Because if you just get rid of your will, it's like you did nothing. So it's no longer into play, and it's very difficult to prove a copy of the will. It must be the original document. As a matter of fact, as an attorney, we would tell people, do not remove the staples. You're not allowed to remove the staples. Once the lawyer puts it together, they staple it, you can't remove the staples. It's got to be intact when it's presented to the court. Does anybody else have any other questions?
I have a question, Professor.
Sure, go ahead.
Back to rent and lease and all that good stuff. Let's
Sure.
say I'm renting an apartment, right?
Yes.
And for some reason, like it gets damaged or destroyed or a fire happened, but it wasn't caused by me or anything. It just happened on its own.
Mm-hmm.
Would I still be obligated to pay rent if I can't live in that apartment?
It depends. Do you have insurance? That's when the
Yes.
insurance is going to come in. You're not going to be as long as you had nothing to do with the fire or the flood or whatever. If it's no longer habitable, then you may not have to pay rent. But if the landlord comes in and makes everything brand new within a couple of days or a week or something, then you would have to go back to paying it. And usually people would have insurance to cover the loss of personal items, or if the building burned down, then the landlord would have insurance on the building itself.
Okay. So let's say like the repair does take more than a month. What would happen to the lease, or what would happen?
You can, if you were not able to live there and you had to go live somewhere else, then you don't have to pay rent for that month. And I think that would be something that the landlord's not going to give you a problem on.
Okay. Okay, thank you.
Okay. Any other questions?
Hey, Professor, something we didn't get into was subsequent wills, like
Oh yeah, I can talk
after,
about it, but I don't usually test on it. So let's say you do a will
because
today.
it was on the syllabus.
Okay, so let me talk about it. Those are subsequent wills are called codicils, CODICILS. And let's say today I do a will and I name I give I give my husband, my kids, all that good stuff, but I also give my neighbor $1,000, give my niece $1,000, give my nephew $1,000. A month later, a month goes by or X years go by, I want to do a new will. I want to keep everything the same way it was, but I just want to change something small. I can do a codicil. It's basically an amendment to my original will where I'm just changing something. If you're going to change the entire will, you might as well just do a brand new will.
Okay.
Codicils are not used as often now because attorneys usually have their wills on a Word document, so they can just edit it and then have a brand new will and a brand new signing ceremony rather than just do a codicil. So it's a freestanding document.
All right. Thank you.
You're welcome. Anybody else? Anybody else on any questions?
Can a lawyer get in trouble for destroying a will with somebody that's like not the family? Is that like
yeah, that's going to be like legal malpractice. I mean, that's legal malpractice, that's fraud. There could be criminal liability because they're doing something, like that. They're doing something that's.
And he can't say that he just lost it and write the.
Well, that's why like you'd.
Like, will that spark an investigation?
It could. It depends on how hard somebody pushes it. Don't forget, if he says he lost it and he writes an affidavit, then a copy can be probated as if it was the original. But if his intent is to destroy it and then say, listen, I never actually had it, I gave it back to my client, then it's going to be a lot harder to prove. So then it's going to be like, you'd have to have eyewitness testimony, maybe somebody that was with the person when the will was drafted, and then they would say, no, the will, the attorney said he was going to retain it. I remember that distinctly. And then it becomes a battle of who says what and who's more credible. And whether or not, as a matter of fact, just as an FYI, like there's been attorneys that get disbarred. That means they lose their license for doing bad things. And if that's ever proven by preponderance of the evidence, right, because it's a civil case, if it's criminal, you're going to bring like fraudulent action, then it will be beyond all reasonable doubt. Depends on whether or not it's proven. Depends on the testimony and the credibility of witnesses.
Okay, interesting.
Yeah, I love this stuff. I could talk about it for hours. I won't, but I could. Does anybody else have any questions? Going once? Going twice? Okay, have a good night, everyone. Good luck on your exam next week. If you have any questions, you can email me, okay?
Good night, Professor.
Have a
Good
good
Good night,
night.
everyone.
Thank you.
Good night.
Professor.
Bye-bye.